Good afternoon, everyone. My name is Lluc Cerda. I'm a Senior Managing Associate of the Calgary office of Samfiru Tumarkin. We're here today live to answer your employment law questions. We're at the Employment Law Q&A. Thanks for joining. So feel free to put your questions in the chat. I'm going to get to as many of them as I can over the next half hour to give you guys a little bit more information on your employment rights. One thing that's been coming up a lot in questions that I've been receiving from people contacting me here at the firm is just cause termination. So just cause termination, not everyone really understands what that is. It's when you're terminated for disciplinary reasons. If you punch someone in the face at work, for instance, or if you steal from your employer. So that allows the employer to terminate you for just cause, which means you're not entitled to any severance. What I've been seeing a lot, however, is employers who are a bit quick to allege just cause. And in fact, I've been telling a lot of people that you actually have the right to have that determination that the employer had just cause to terminate you. You have the right to have that reviewed. All right. And if it's found that there is no just cause to terminate you, then you're entitled to your severance package. So I see sometimes, unfortunately, employers be very quick on the trigger for terminating someone for just cause, with saying that they won't pay you any severance and you've done something awful. We have a lot of success on many of our files getting that decision, that just cause finding reversed, and getting our clients the severance package they're entitled to. So that's definitely something that that's the situation you're in where you've just been terminated for just cause, very important that you contact us. Let us know exactly what the employer is alleging, because in a lot of cases, the fact is that whatever you did, if the employer is able to prove that you did it, whatever you did is not so serious as to disentitle you from your severance package. All right. There's a lot of things that need to happen. Progressive discipline. You've heard of this. You need a warning before the employer jumps straight to termination. If performance issues are involved, then you need to be looking at performance improvement plans, additional coaching. It's very hard to terminate someone for just cause, is the point I'm trying to make. So if you're in that situation, feel free to reach out. We'd be happy to speak with you. So if you're looking to reach us, you can contact us right there. The website is on the screen right now, employmentlawyer.ca. employmentlawyer.ca. You'll be able to contact us immediately, set up a consult with me or one of my colleagues here at Samfiru Tumarkin. So we have a question also coming in right now from M. Renter. My previous employer owes me over $4,000 in unpaid wages. They aren't responding to me at all. What should I do? So you have a few options. M. Renter, you can actually make a complaint to the Ministry of Labor for these kinds of things. So for instance, if your employer is shorting you on your pay, on your vacation pay, on your statutory holiday pay, you can contact the Ministry of Labor in the province where you live, and they can open an investigation. And if they agree with you that you've been short paid, they will order the employer to pay you what's owed. All right. So that's a good way of obtaining that unpaid compensation. So in Alberta, you would go to the Alberta Ministry of Labor. There's Employment Standards branch. You can make a complaint online, and actually, it's before you even finalize a complaint, they'll draft a letter for you that you can send to your employer. And if your employer still refuses to pay, then they'll investigate. But oftentimes, just by sending that letter to your employer, gets your employer to come around and paying you. All right. So that's a good way to go. Search for employment standards complaint in the province where you live. We have another question coming in from Sean on YouTube. I'm on an unpaid leave because the workplace environment is too toxic. I don't think I can return. Am I entitled to severance? So potentially you are, Sean. Yes. So essentially, if you're in a situation where you're in a toxic workplace, and this results in you having to take a medical leave of absence, which I guess is what's happening in your case, Sean, then if the employer was involved in that in any way, then that might entitle you to severance, because you may have been constructively dismissed. All right. There's a lot that goes into this. It's hard to assess. It's not simply automatically because you're on a medical leave that you're entitled to severance. I want to make that clear, even if it's related to issues in the workplace. We would really need to speak to you to see what these issues are, how involved the employer is. So, for instance, if you have a workplace conflict with one of your colleagues, but your employer never hears about it, it's hard to say that your employer did something wrong, right? So there's usually a process in place, making a harassment complaint, a violence complaint, and have that investigated. If your employer fails to investigate it, or finds that nothing happened when in fact something did happen, then that might entitle you to severance. So we have to get a bit more details from you, Sean, on that. But you definitely, it is a thing that, yeah, if you're the victim of a toxic workplace environment and that leads you to take a medical leave of absence, that could entitle you to severance, all right, as a constructive dismissal. Now, you might be wondering, well, okay, fine, but how much severance am I entitled to in that case? So we have a great tool. It's up there on the screen right now, pocketemploymentlawyer.ca. You go to pocketemploymentlawyer.ca. We're going to ask you 4 simple questions. And based on your answers, we'll tell you what we think your severance entitlements would be, all right? So there's no need to provide any confidential information, your email or anything like that. It's just a way for you to determine what your severance entitlements are. So if you're interested in knowing how much we're talking about here, then definitely take a moment to look at that. Because I would say every few weeks I get a question from someone calling into the office saying, how do you calculate severance? Is it, 1 week per year of service? Is it 3 weeks per year of service? Go there, you'll see it's a lot more than 1 week per year of service. Usually your full severance is likely in the range of at least a month per year of service, if not more. So we're definitely talking about substantial sums of money in some cases. So you just want to make sure that you know what you're owed, and so that you can have a clear understanding of what your legal rights and what your financial opportunities are here. All right. So pocketemploymentlawyer.ca. We have a question here from JX2. JX is asking, what is owed in BC when you work more than 5 hours before a meal break? So where you work 6 hours before a meal break. So what JX is referring to is that there's generally going to be a certain break requirements in employment standards legislation. If the employer is in breach of the break requirements, my experience is that doesn't necessarily entitle you to compensation, JX2, but you can make a complaint, and that might expose the employer to fines from the Ministry of Labor. So you would make a complaint to the Ministry of Labor saying that they're not respecting. That's a long time to go without a meal break. I totally agree with you that that's already 5 hours is long, right? They're giving the employer a lot of rope here, and if the employer can't work within that, imagine an 8-hour day and you're going to lunch at 3 p.m., right? That's way too late. So definitely you can make a complaint to the Employment Standards Department of the Ministry of Labor, and they'll investigate to make sure that the employer is in compliance with your rights under employment standards legislation. There might not be financial compensation from you, but there would be an order to allow to force the employer to respect your employment standards rights. So that's definitely the way to go with that. Start by discussing with the employers and listen, this is not you're breaking the law here and doing this so late. And if they still insist that they're not going to change, then it's to bring a complaint to the Ministry of Labor. We have another question coming in from Sarah on Facebook. Sarah asks, can my employer reduce my hourly pay for the same job I've been doing for 20 years? So in essence, no, Sarah. Basically, if your employer reduces your hourly wage, that can amount to a constructive dismissal. So that puts you in a situation where you have to make a choice right now. Do you have a choice of either continuing to work for the lower rate of pay, or saying, well, this reduction in pay amounts to a constructive dismissal. I'm going to quit and pursue my severance entitlements. All right. And since I've been with you 20 years, I have substantial severance entitlements in this case. All right. So again, if you've been there for 20 years, Sarah, and you want to have an idea of what your severance entitlements might be, visit pocketemploymentlawyer.ca and you can use our severance pay calculator to figure out how much you might be owed. Now, that said, the employer is entitled to a little bit of flexibility. All right. So it depends how much they're cutting your pay. I know it's not a great thing. Honestly, I think that they were to reduce your hourly rate by just $1 an hour, that should be a constructive dismissal. But the law says different. So if it's really just reducing your pay and there's no other changes to your duties or working conditions or anything like that, an employer can reduce it by up to 15%. But more than 15% amounts to a constructive dismissal. Okay. So imagine a scenario where you're working and you're earning $25 an hour and they reduce your compensation to $20 an hour. So they've reduced it by 20%. So that, in my view, and I think what the law states is that would amount to a constructive dismissal. You have no obligation to accept that, and you can instead go after your severance. All right. We have another question coming in from Mark on YouTube. Mark is asking, I worked in construction as a site super and had to take a leave due to an injury. When I was brought back, I was pushed into a completely different role. My complaint landed on deaf ears and I eventually resigned. Was I owed anything despite resigning? Yes, Mark. So if you are demoted following a return from a medical leave, that can firstly entitle you to severance. And potentially there's a human rights component to it as well, all right, which might entitle you to lost wages and human rights damages, all right. So essentially a demotion can also be a constructive dismissal, all right. So you work as a site super, you come back, they tell you, no, we want you on the tools now, we want you doing drywall, whatever it is, that can amount to a constructive dismissal. Now, you haven't mentioned whether they would have continued your rate of pay or whether they were also going to reduce your rate of pay. If they were also reducing your rate of pay, it just makes your case even stronger, right? So definitely that's something that you want to talk to us about to flesh out exactly what happened. The other thing to remember is that you have 2 years from the day that you resigned in this case, Mark, to start a lawsuit, but only 1 year if you are going to bring a human rights complaint. So it's important that you not sit on this for too long. There are some important dates that need to be respected. So you can ask us for more details. If you want to email us directly, that's the email's on the screen, help@employmentlawyer.ca. We can communicate with you, get in touch with you to get the details and let you know what your rights are. Yeah, so that's a very important kind of area that I see a lot as well, especially in construction. You come back from a leave and all of a sudden they've replaced you with someone else. They have a job for you, but it's earning a lot less than you were before, or not even in the same job. Basically, you're now reporting to one of your former colleagues or the person that got promoted in your absence. You're back on the tools. You're doing more heavy duty lifting. Depending on your age, especially if you're coming back from a medical leave, that can be very hard to do, right? So it's important that you speak with us as soon as the employer is telling you, listen, your old job is gone. Here's what we can offer you. Why don't you go ahead and accept it? Speak to us so we can tell you a little bit about your rights in that situation. Now it seems, Mark, that you resigned in protest, and that was probably the right thing to do. The other thing is you don't have that much time to think about it, right? I mean, basically, if you say, well, listen, I'm going to try this demoted role, it might work out, let's give it a shot, and you realize that a year later that really this doesn't work for you, you've lost your right to sue for constructive dismissal, right? So you can try it out for a bit, but really not too long. And I'm saying a year is well outside the range. In Alberta, we've had discussions from the Court of Appeal saying, really, you have 3 weeks, which I think is really short and hasn't been followed that much by the lower courts, but definitely it should be on your radar. If they're cutting your pay, if they're changing your duties, if they're demoting you, that's when you pick up the phone, give us a call, or just visit us. Our website, again, on the screen is employmentlawyer.ca. All right, we'll set up a time to speak with you so that we can advise you on what your employment rights are and what's the way to move forward here to protect your severance. We have a question coming in from MP. MP is asking, under what circumstances can an employee challenge being asked to work out of a basement of a building? No known health and safety concern or known issues for the building. They work out of the same building now. Essentially, I'm not exactly sure what the issue is with working in the basement. I haven't seen this basement. I don't know if the employee has provided some details of what exactly they take issue with in the basement. It could be several things. For instance, there might be a lot of steps and this person has a mobility issue. It might be that it's not well lit and makes it hard for them to see or strains their eyes. It might be not as warm as other parts of the building. There could be a lot of issues, or it could just theoretically just be a very unpleasant place to work. It also depends how long they've been there. Have they always worked in the basement, or is this a new environment for them? Whereas they had an office, on a higher floor back in the day. So your work environment, if I would say you want to work collaboratively with your employer, whether that will amount to a constructive dismissal that you're being asked to work in the basement. Again, I kind of sound like a broken record today, but we would need the full details of what exactly is going on. When you have a constructive dismissal, I guess there seems to be a breakdown between what the employer wants you to do and what the employee thinks is their job, okay? And what's hard for a lawyer like me to advise on is what was the arrangement prior to the dispute arising. So without knowing what the arrangement was prior to the dispute arising, it's hard to know how that arrangement has changed, okay? So saying, for instance, that, my compensation has been cut. Well, what was it before? What is it now? That's an important consideration to know if the change was substantial enough. Because for a constructive dismissal to be successful, not only does the employee have to show that there was a change in an important part of their working conditions, but it has to be a substantial change, okay? So what I'm always looking to see when I hear someone saying, well, something has changed at work, is that a substantial change? Which, of course, if you're asking me about it, it's because it's substantial to you. But basically, we have to kind of look outside of that, taking all matters into consideration, whether objectively that's a substantial change. So for instance, someone who's worked in the basement for 20 years who now says they don't want to work in the basement, and there's no mobility or light issues, nothing really has changed, it's hard for me to tell that person that's a constructive dismissal, right? If, however, this person has been working on the ground floor, walks with a cane, and now is being asked to go up and down flights of steps several times a day, that could very well be, firstly, someone that needs to be accommodated for a disability, a human rights violation, potentially a constructive dismissal. A lot of things can go into play there. So really knowing the context really allows me to answer that question with a bit more detail. And it's hard to do that here today, just with the chat, but feel free to give us a call. If you feel that you might have been constructively dismissed, we know what questions to ask to let you know whether you have entitlements to your severance, or whether this is not enough of a substantial change on its own to entitle you to severance. So you can reach out to us, employmentlawyer.ca. Our number is on the screen here as well. That's 1-855-821-5900. We'd be happy to talk with you, go into those details a little bit more, and let you know whether you are entitled to claim constructive dismissal in this case. We have another comment coming in from Lisa on Facebook. Lisa is asking, I have been approached with a life-changing opportunity. However, my current contract I signed in 2018, there is a non-solicitation clause in there. What are my options? So you say it's a non-solicitation clause. So it depends what the life-changing opportunity is. So what's important to remember is a non-solicitation clause is quite different from a non-competition clause. So a non-competition clause says you can't go work for the employer, for the competition, okay? A non-solicitation clause doesn't say that. It allows you to go work for the competition. Generally, what it says is that you can't take your former clients with you, your former staff with you, any former suppliers with you for a certain period of time. But you're free to go work for the competition. Now, what we end up seeing is that a lot of non-competition clauses are disguised as non-solicitation clauses. So the title of the clause says non-solicitation, but it says that you can't go work for the competition. In reality, the title of the clause is not important. What does the clause prevent you from doing? And if it prevents you from going to work for the competition, then it's a non-competition clause. Non-competition clauses, Lisa, are very hard to enforce, okay? So there are a lot of reasons why a non-competition clause might be unenforceable. For instance, what the law requires is the employer to show why this non-competition clause is required to protect the employer's interests, okay? So, of course, not having competition is a commercial interest, but that's an illegitimate reason to enforce a non-competition clause. Unless you're a very senior member, and I'm talking CEO, maybe VP, a very senior member involved in strategy with the company, non-competition clauses are going to be very hard to enforce because there's no legitimate business interest in preventing you from going to work for the competition. Sure, you might know some things about the employer's affairs, but that's going to be covered by the confidentiality clauses, probably also in your contract. All right, so you can go work for the competition. Doesn't mean you can take trade secrets or client lists with you. And in fact, I advise you not to, but you can definitely go work for the competition. So short answer, Lisa, I guess, is again, we'd have to look at the terms of the clause. Another issue with a lot of clauses is that they're too broad in terms of geographic scope and in terms of duration. So I've seen 9-year non-competition clauses. You're going to have a lot of trouble enforcing that as an employer. I've seen non-competition clauses that aren't limited in any way in scope, which means that if any competitor anywhere in the world, potential competitor, you can't go work for them, right? And so that's going to be hard to enforce, right? I mean, say you work for, we'll just use a doctor's office, and they prevent you from working in any doctor's office anywhere in the world. How is a doctor's office in Europe competing with this doctor's office of yours in Calgary, Alberta? It's not. So it's overly broad. Now you're going to tell me, yeah, but I'm not going to Europe. I'm going to a doctor's office right across the street, right? Well, first thing we have to decide is this clause enforceable in all cases, right? So if it does prevent you from going to work for a doctor's office in another country, then it's just unenforceable, right? We look at it, what did it say at the time that you signed it? And then if it's unenforceable, it doesn't matter if you went across the street or if you went to Europe. All right, so that's the kind of root tree analysis that we do in determining whether you're bound by this non-competition clause. That's I guess what I'm concerned, what I would say, Lisa, is I'd have to have an idea of what your current role is, how senior it is, and I'd have to also want to take a look at your non-competition clause. But in general, I can't say this is necessarily the case in your case, but in general, non-competition clauses are very hard to enforce. We have another question coming in from Nicholas. Nicholas is asking, my company is being sold to a competitor. The new owner's offer doesn't include a lot of my current job perks and compensation, such as a car allowance, cell phone coverage, etc. The previous owner is pressuring me to accept this offer so he doesn't have to pay severance. What can I do here? So basically, when a new owner takes over the business, sometimes they'll extend to you a offer of employment. All right. So, and if you sign and you stay with them for a certain amount of time, that'll extinguish your right to severance from the old employer. Because when the old employer sells the company, it might entitle you to severance, right? Because the new owner is not required to employ you, and you're not required to work for the new employer within reason. All right. So what I would do in this case, Nicholas, is I would write to the new employer and tell them, well, listen, I'm happy to work with you, but I have some edits to this. I have a counteroffer to your employment contract that you're offering me, and these counteroffers, well, I want my car allowance, I want my cell phone, I want, a better amount of severance guaranteed in the contract. And for that, for instance, Nicholas, I would invite you to go to our Pocket Employment Lawyer website, pocketemploymentlawyer.ca. Calculate how much severance you're owed from your old employer, and tell your new employer, I'm willing to work with you. So say, for instance, you're owed 12 months of severance from your old employer. Tell them, something to the effect, well, I'm owed 12 months from the old employer, so I want either a guarantee that you'll employ me for 12 months, or that if you don't employ me for the full 12 months, you will pay me severance equal to what remains on the 12-month notice period, right? So if you let me go after 6 months, you owe me 6 months of severance, plus any severance that accumulates after the 12 months. So after the 12 months, I want, a month per year of service or something like that. So these are definitely negotiable. You do have some leverage here, Nicholas, because your old employer is going to want to work with the other side so that you go work for them and the new owner, and so that they're off the hook of having to pay you severance. So you do have some room to negotiate here, is what I would say. And if ever the new employer says, well, you know what, we don't want to employ you anymore, then you may be owed severance from the old employer. All right. So this is kind of tricky. Before you turn down the job, though, I would say, Nicholas, it's important that you speak to us. There's a way of doing this. And more generally, when you're dealing with constructive dismissal, there's definitely a way of doing it and a wrong way of doing it. So it's important to have a lawyer on your side so that you say the right things, you make appropriate offers, counteroffers, because all of this will eventually be viewed by a court, right? If you write to your employer and say, and you're very cavalier in dismissing them, or you refuse to participate in an investigation once you've made a harassment complaint, or you make demands that are unreasonable in the eyes of a court, that might, really affect your likelihood of success on a constructive dismissal claim. So it's important to have a lawyer by your side who can either communicate on your behalf, or who can at least tell you what to say and what not to say. All right, because I've seen people, they think they understand the law, and they make these assumptions, and then they communicate these assumptions to the other side, and it can really jeopardize your claim. So better to have an employment lawyer review your case, tell you what you can and can't do, and guide you through the process of getting you to the severance package that you're owed. Very important to keep that in mind. So we're about out of time for today. If anyone's about to hit enter on their question, please do so. Please do so now. We got our next show is with Lluc Samfiru. He's on Wednesday. He's at 1 p.m. Eastern time. If you had a question, didn't have time to ask it, feel free to join at 1 p.m. Eastern on Wednesday. He'll be happy to answer your questions as well. My name is Lluc Cerda. I'm Senior Managing Associate of the Calgary office of Samfiru Tumarkin. Thank you all for joining. It's been great questions today, and I had a great time answering those for you. I hope this was helpful, and I'll be back again in a couple of weeks, on Monday the 25th. All right. And MP says, thank you, Luke. Helpful as always. I appreciate it, MP. Thanks for joining in. All right, everyone. We'll see you next time.